because the Chief Justice had ruled that they were resigned by operation of law. Well, we are asking for an order directing them to give effect to that resignation. And thirdly, we are asking for an order restraining cabinet from meeting because they are disbanded and they are no longer in existence.
Why are these necessary, absolutely necessary in your opinion?
It's unfortunate that we have to resort to this kind of strenuous efforts in the court to get a government to obey the clear language of the Constitution. It is unfortunate that the citizens of this country the citizens have to resort to this kind of extreme in getting a government simply to comply with the Constitution. Every one of you would have read the Constitution, and every one of you know that Article 1066 says that upon the successful passage of a no confidence motion, cabinet inclusive of the president shall resign. 10 months after, we are here battling to get the government to give effect to that provision of the Constitution, which is our supreme law. And this is the level to which we have descended. And rather than the Attorney General come here and concede as the principal legal advisor under the Constitution of the government of Guyana, he comes here and says that it is an abusive process. It's an atrocious contention. He should be coming here, asking the court apology, and going back to get his cabinet to resign in compliance with the Constitution. He comes here with a straight face and says that we are trying to abuse the process of the court, whereas all we are trying to do is to get constitutional compliance, which is the law of the land, which is the rule of law, which is what our constitutional democracy demands.
Do you see the constant returning to the court affecting the president, for instance, moving ahead with making a solid date or announcing a solid date for elections? It has no probably correlation, but it seems that every matter that comes to court has an effect on that particular decision.
Well, the president seems incapable of acting voluntarily on any given matter touching and concerning elections after the no confidence motion. You would recognize that pressure has to be brought to bear before he acts. And the only type of pressure he seems to be responding to is court orders, though he's not responding as he should, because he's not complying with all the court orders. It is the one form of pressure that seems to attract some degree of response from the president and his government. Because if you march, you're not getting anything, and so on.
Yes, you said that in the affidavit that you filed. Why do you believe so?
That Mr. Nandala is fast becoming a vexatious litigant. What has he done? He's come today. For the last 9 months, I'm hearing the same arguments. The cabinet and president must resign. This learned Chief Justice dealt with that issue. It went to the CCJ. The CCJ rejected it. Clearly said that the government remains in a different mode, an interim government and all. It's a waste of the court's time, the court's resources. So we litigating the same issue that the highest court is a disrespect for the CCJ too. You know, and Mr. Nandala and his party, they have always disrespected the CCJ.
So you don't believe there's a basis for the motion itself?
Hasn't the CCJ determined this issue? It was a consequential order sought by Mr. Nandala for the leader of the opposition in the CCJ. That the cabinet and including the president resigned. It is clearly rejected. Okay, so there's nothing that is there left to be fleshed out from this simple issue.
Thank you.
Dr.